to criminal proceedings week. Please don't forget to like, subscribe, share and comment, and also put on the notification button, because here we analyze all the workshops from both first intake as well as the second intake. So please make sure that you subscribe, like and comment and share, so as you don't miss any analysis, because if you listen up to the end of this video, I will give you tips on how to pass oral exams. So please, if you want to pass oral exams, then listen up to the end of this video. I will give you the tips that can help you to prepare as well as pass an oral exam. So let us begin. We are looking at pre-trial proceedings to develop skills required among prospective advocates and judicial officers in the performance of various roles during pre-trial proceedings in the administration of criminal justice. So, course aim to develop skills required among prospective lawyers, advocates in the performance of various roles in the administration of criminal justice during pre-trial proceedings. So basically, when we talk about pre-trial proceedings, these are proceedings that happen before the person is charged. So once you have been, once you are a suspect, you are arrested and brought to the police before you are charged, then that's what we are calling pre-trial proceedings. So the proceedings range from conduct of arrests, interviewing of witnesses, retrieval of relevant evidence, compilation and perusal of a police file, advising on the areas for further investigations, recording of an extrajudicial statement, conduct of identification parades, and alternative dispute resolution. So when we talk about perusal of police file, we shall be given different statements. So basically what happens is, once the police is involved in the case, they call people who make statements at the police. So these statements are the ones which the state attorneys look at, so as they can identify offenses. So that's what we shall be looking at, perusing a police file. So we shall be required to peruse these police files, and then shall be required to charge the appropriate offenses. So these proceedings, so shall look at also advising on the areas of further investigations. Then in case you find that the statements are lacking with some key evidence, then you can also proceed to advise for areas of further investigations under Article 120 of the Constitution. So shall also look at recording of an extrajudicial statement. An extrajudicial statement involves, for example, a confession. So in case someone, the suspect is making a statement and then concedes and says, I'm the one who stole that car, that becomes a concession. So we shall look at the Evidence Act, basically the person that's supposed to take a confession. And the Evidence Act provides that you must be above the rank of the Assistant Inspector of Police. Then we shall also look at the process of conducting identification parades. We have case law that has elaborated on how identification parades should be carried out. One, of course, people should be of the same height, wearing the same clothes, and there should not be any other person in the room. So basically, that procedure of conducting an identification parade is also very, very important. And also ADR mechanisms include mediation as well as reconciliation. So, but at the end of this workshop, the learners should be able to, one, peruse a police file and preparation of a legal opinion, advising on the possible offenses disclosed, and advising the police on the areas for further investigations. So basically, we shall be looking through different police files recorded by the police office, by the investigating police officer, by the complainant, by the witnesses, and also by the suspect. Then two, handle scenes of crime and recovery and preservation of evidence, exhibits and recording of confessions. So we shall basically look at the exhibit management guidelines, which basically talks about how you should handle a scene of crime. You have seen where accidents or maybe incidents of murder have been reported. The police in white clothes comes and then surrounds the scene. They are picking things, putting in white bags, wrapping with gloves. So that's what we call basically how do you handle a crime scene. And we shall be looking at also recovery and preservation of evidence and recording of confession. So we have talked about recording of confession that must be above the person of assistant inspector of police or maybe a magistrate. I think section 27 of the Evidence Act. Then we shall look also at how you manage exhibits. So we shall look at what we call the chain of custody. That you must be able to get this evidence very well, keep it very well, that it's not tampered with. So once the evidence has been tampered with, then we shall say that the chain of custody has been broken. And once the chain of custody is broken, that means the evidence cannot be relied on in court, or it will be given little weight. Then we also look at direct police on the conduct of arrest and handling of different kinds of suspects, offenders, including diversion. Diversion basically is when we have children. We do what we call diversion by looking at other options, not the ones we know. And we have the children diversion guidelines, which I shall also look at. Then we shall look at police bond and ADR. Basically, police bond, the one you apply from police, which the president is against. Then draft relevant documents for institution of criminal proceedings before a magistrate's court. So we shall see how now do you draft documents to institute criminal proceedings before a magistrate's court. So before the magistrate's courts, we proceed by charge sheet. We proceed by charge sheet. And a charge sheet can be instituted by a private individual or DPP or police. So basically the three, by police, by private individual, but also by DPP. Then draft administrative complaints, lodgment, and corresponding powers of the office of the DPP. So we shall see like applying for unconditional release to the office of the DPP. Identify and address possible dilemmas arising during pre-trial processes. So when we talk about pre-trial processes, we are looking at the period before you have been charged. So instructions: assume that you are the resident state attorney at Chira office of the Director of DPP. The case file has been sent to you by the officer in charge of criminal investigations and intelligence department at Chira divisional headquarters for perusal and tendering of legal advice. Summarize the relevant facts, issues, and replicate with the case file. So basically, we shall have to look at the different case files or different statements, and then come up with basically the appropriate facts to help us to reach to offenses. Then identify the possible offenses disclosed by the facts and evaluate the evidence on support of the offense identified. So basically, when we are evaluating evidence, we are looking at the offenses we identified, the ingredients of that offense, and trying to ensure that we have enough evidence to prove those ingredients. Remember, in criminal proceedings, he who alleges must prove. Section 101 of the Evidence Act says that he who alleges must prove, and the burden of proof is on the prosecution, like the way we saw in the case of Warrington versus DPP, which was also reiterated in the case of Sechiterico versus Uganda, that in all criminal proceedings, the burden of proof is always on the prosecution. The standard of proof, Warrington versus DPP states that it's always beyond reasonable doubt, and when it shifts to the defense, it's on the balance of probabilities. So you have to first cite those sections: section 101 of the Evidence Act, the case of Warrington versus DPP, when you are evaluating evidence. Then when you are identifying offenses, you have to talk about the presumption of innocence under Article 28.3a, the principle of legality under Article 28.7, and the definition of an offense in Section 1 of the Penal Code Act. So those you must first, the preliminaries you have to talk about. Then C, should you find the evidence on record inadequate, identify areas for further investigation, if any, and explain why. So the areas of further investigation is, after looking at your statement, is where you think that they need to maybe they need to get more witness statements, or maybe they need to get any other more evidence. So you advise under Article 120, advise the DPP so as they can carry out additional investigations. So assume that the investigating officer has been informed by an informer that the printer is still in factory of the person who bought it, and that the accused still is in possession of 5 million of the money he received as the purchase price for the printer. Advise the police on the proper procedure to follow to recover and preserve the exhibits for future court use. So basically here we shall look at search and seize. Under the Police Act, the police have powers to search and seize if they are under a reasonable belief that any evidence is an area. So we shall also look at the exhibit management guidelines, which basically states how the exhibit should be labeled, marked, and stored, so as we don't break the chain of custody. The chain of custody is basically from how you're dealing with the exhibits, or maybe with the evidence. So assume that you are an advocate in private practice and your client is a 17-year-old charged with assault occasioning actual bodily harm. The security guard at High Tower School. What procedure would you follow in order to have the matter resolved without recourse to court? So basically here we have to go for diversion. Diversion are like alternative dispute resolution mechanisms that have to be adopted in case you have a child. And also we have the children guidelines we shall be relying on. If assume you're an advocate, yes. If assume the role of an advocate in private practice, and upon perusal of the case file you find out that your client was mistakenly charged or with a mistake identity because it was allegedly dark, you find out that the alleged offense of theft or print from Higher Tower School actually happened while he was away in Zambia attending the farmers conference. However, the police have refused to heed your client's pleas. They say that they just want to escape justice. What course of action would you take? Draft an administrative complaint with the DPP. So basically, I would write the DPP in a way of a letter raising your defense, which is an alibi, and attaching all the necessary evidence you have. So once you have written by letter the DPP, then they would have to consider your evidence, and then they will make a decision on that. But you have to write by letter to the DPP. So assuming the role of an advocate in private practice, and upon perusal of the case file you find out that your client was mistakenly charged owing to a mistaken identity because it was already dark, you find out that the alleged offense of theft. So basically here you have a defense of what? Of alibi. So you would have to write the DPP to consider that and evaluate, and they see whether they still can bring those charges to what? To the DPP. Once the DPP finds that you have a very good case, they can withdraw the charges, because under Article 120, remember, the DPP has powers to withdraw charges once they find that they don't have adequate evidence. So when we look at the police file, we have Uganda Police. This is by the complainant, who is also Prima. The above stated particulars and addresses are mine. My school is called High Tower School. The school is found in Borido. I bought the school from Bugembe. After the purchase, I retained the director of studies. He helped me while I prepared my new team to take over the school. The school has a main gate and another small gate at the back of the school. We bought the school with a lot of furniture and a big heavy-duty printer that was housed at the back of the head teacher's office. Bugembe still had access to the school. In order to finalize the handover, I had given Bugembe 2 months to completely vacate the school properly, including all of officers. The school had armed guards at the main gate. We also retained the guards. During the Mass of May 2024, the head teacher informed me that Bugembe had come in the previous day while driving a pickup truck and stayed in till late, and that the printer was now missing. When I checked my phone, I found a missed call at around from the security guard known as Kure. When Bugumbe had left the school later carrying out what he bought was an office desk. The guard then informed me that he later discovered that the big printer was missing. So basically here we are looking at theft contrary to the Penal Code Act. And remember, theft, the ingredients you must prove: one, that there was a transportation, also ownership of the property. So you have to make sure that you bring out all those ingredients of theft. The property being capable of being stolen, all those things. So I recall the letter called Uma, but he kept rejecting my calls after several attempts. He then told me, say that he was too busy, but also denied having taken or even seen anything. The printer yesterday I heard from police that Karbala Science, a neighbor to Johnson, was arrested with a printer engraved with the initials of my school and was trying to install it at his factory. The police recovered the printer from Kalbata, says that he bought it from someone who brought it to him. He says that he remembers the face of the seller and the truck that delivered the printer to him. The printer is still at police and is valued at Uganda shillings 98 million. So basically here, what we are seeing is the printer is 98 million. So basically we are dealing with what? With theft. With theft. They can also be theft. We can also look at conspiracy and also trespass. Then we also see here the statement of Janice Boaz, who is a teacher. I wish to say that I'm the current director of the studies at High Tower School. I also served in the same position while the school was under the former owner. I recall very well this month of May that Bugembe sold his school to Prima. I was retained as a caretaker. The school has a lot of furniture and equipment and a big printer housed in the examination room. I run all the affairs of the school generally, and we have school guards. So basically here what we can see is there is a likely of theft. Then you can also look at conspiracy and also trespass. So this is a statement of the security guard. So we also have the statement of the witness. Let me read the statement of the investigating officer. The above stated particulars and address are mine. I received the case file. I recorded the statement. The purchase of the school, the company retained the director of studies. The company that had also retained the old armed guards. Having got the information about the theft of the printer, went and reported to Chira police. So you can also see that he or she is confirming theft. When I read through the suspect's print statement, they are saying that the above stated particulars and address are mine. I sold my school to Prima. The school is called High Tower. Yes, I was completing a handover, but I had already handed over. The school has also deployed its armed guards at the main gate. It is true that my driver went to the school. I was surprised to receive a call from police. Must explain how his neighbor got that printer. I know Kasenge to be a crafty man. I know him very well, beyond doubt. I had gone to Busia for business. It's not true that I went to the school to steal. So basically it brings the defense of alibi, because he's saying that he had gone to Busia. So basically that is it for workshop 1. We shall be looking at theft, conspiracy to commit an offense, as well as trespass. Those are basically the 3 offenses which I can identify. Then from there, but please, in case you want mentorship, we have a mentorship program that covers all the 4 campuses, and we are basically online. We discuss on Saturday and Sunday, and then throughout the week we give audios in the group, and also a summary of cases on the reading list. And in case you have any consultation, you can contact me or either of my colleagues. So we issue notes of the workshop and also discussion. So in case you're interested in that, students pay a monthly subscription fee. In case you can afford that, then you are welcome. You can text me on the number on the bio. We shall give you further guidelines. But in case you don't also afford, then you can also listen to the highlights. Okay, let us go to case file number 2. They are saying that this workshop aims at further introducing learners to pre-trial proceedings, including perusal of police file, demonstrating the role of the police of the DPP. So the role of the DPP is under Article 120 of the Constitution. When you read Article 120 of the Constitution, they give you a lot of powers of the DPP, which include to withdraw from a case, to order for further investigation, and institute charges. The interviewing clients in police custody, ability to secure pre-trial remedies. So police custody basically means that people are still detained at police. So you can apply for what we call police bond. Then we shall also look at other pre-trial remedies, for example, application for police bond, and conditional release, basically those ones. Then we shall also recording confessions or extrajudicial statements from the accused persons, and we say that confessions must be recorded by a person who is above the rank of assistant inspector of police or a magistrate. So learning outcomes, at the end of the workshop, the learners should be able to execute the mandate of the DPP, peruse the police file, comprehend the contents therein, and guide police on carrying out investigations, prepare appropriate documents for court in accordance with the establishment rules. So basically here the court documents, we are drafting the charge sheet. When we are in the Chief Magistrate's Court, we have a charge sheet, whereas when we are in the High Court, we shall be looking at indictment, but that will be in term 2. But for now, we are looking at charge sheets. Identify and portray the various pre-trial remedies available suspects in the criminal justice system. We have applying for police bond. We can also have a writ of habeas corpus where the person can't be found anywhere. We can also have unconditional release, basically those ones. Interviewing a client who is in police custody. So basically a client in police custody, you'll be focusing whether his or her rights have been violated, whether you have access to food, whether you are being tortured, whether you have been granted access to your relatives, things like that. Ethical dilemmas, of course, never take a bribe, like the police officers, also the state attorneys, not overcharging your clients, as well as avoiding conflict of interest, like the way we saw in the case of Uganda versus Patricia Ojangare, where we had, because in Uganda versus Patricia Ojangare, we had the persons who had helped the boss to interdict their employer. He was also trying to represent the employer, and of course the court stated that he was also trying to represent the employee who was being now charged with I think theft. So the court said that was a conflict of interest. So you must make sure that you are not there is no any conflict of interest. So we shall look at the following legislations. Article 23 is on liberty, right to liberty, and Article 23(6) is on right to apply for bail. 28, right to a fair hearing. Article 120, the powers of the DPP. Article 129(1), course of judicature in Uganda. 212, the role of the police. 250, in all criminal proceedings, it's Uganda versus the other person. Then the Penal Code Act and the Police Act. So from there we shall look at your resident Chief State Antoinette Makinde. The above file is sent to you by the OC CID Chira Division, Police Headquarters, for perusal and legal advice. Task 1. Summarize the relevant facts, issues, and law applicable of the case as seen in the police file. Identify the, so basically when you are this is the you do the brief facts, issues, and then the law applicable. Identify the offenses. So the offenses, you first quote Article 28 3A about the presumption of innocence. You look at Article 28(7) about the principle of legality, that you cannot charge someone as an offense that is not prescribed by the law. Then from there you look at, of course, the definition of an offense in Section 1 of the Penal Code Act, and then you proceed to identify the offenses from the facts, and you identify the offense contrary to the section of the Penal Code Act, and then you use the case to lay down ingredients. Then identify the possible offenses if disclosed, on the post to support the evidence. Task 2, suppose you find the evidence adequate, identify areas that require further investigations. So you proceed under Article 120 of the Constitution to advise the DPP to provide areas for further investigations. Then draft the necessary court documents to initiate the criminal proceedings. So the court documents here, we look at, of course, the charge sheet in the magistrate's court. Then assume that you are an advocate in private practice and have been instructed by relatives of the suspect who has been detained at Chira. police advice since 11th. Advise your clients on the pretrial remedies available to you. So the pretrial remedies we have one include you apply for police bond from the police. Then if you cannot get the police bond, you go for unconditional release. So assuming that you have come to the conclusion that court action is necessary, draft the necessary court documents envisaged for this purpose. So basically here you proceed by notice of motion supported by an affidavit whereby you apply for what? For unconditional release from court. You apply from unconditional release from court. Then task 4, assume that you are a grade 1 magistrate and all suspect has told the police that he accepts having committed the offense. He has been produced before you for extrajudicial statement. Demonstrate how you would ensure the statement is properly recorded. So basically here we are looking at how do you record a confession. So you record a confession. Once you must ask the accused whether he has been forced or he's making it voluntarily. Then what language does he understand? Then you read the particulars of the case, ingredients as well as the facts, so as he can confess to everything. So once he has confessed, then you can proceed to take out what we call a confession. Remember, a confession can be taken out by either an instant inspector of police or any other police officer above that rank, or maybe by the magistrate. So basically that is it for this question. Let us go and look into the statements. So 1, we have rental flowers, businesswoman, occupation. So they are saying that the above stated particulars and addresses are mine. I wish to state that I'm a daughter of the late Brazil Makinde. My father died 2024. He left us with instruction that the land we are currently using and residing on belongs to our grandmother, who is his mother. He said we should use the land but not sell it. We are 4 children. We are 4 children of our father, Mr. Beata, Chris, and Runkoni, and all our four of us have built permanent houses on said land. New Year's Day of this year, our brother, commonly known as Badas, surprised us by claiming that our father gave him his land where we reside and have a coffee plantation. We asked him if he has any documents to prove what he was claiming, and he said no. So yesterday at about 12:30, while I was in my house, some people came saying that Badas had sent them. They ordered me to immediately vacate my house as they were going to demolish it and take over the land. When I refused, one of them, who I recognized as Assad, the best friend of Badas, who threatened to beat me if I do not comply. That man threw a spear aiming at my head, but because I was a distant away, I saw him and I dodged it, and it fell on the ground. I ran away and went to the chairman's LC1's home and reported spear and some sticks from the scene. When Badas was later arrested after disappearing for days, he showed us some documents that he claimed were given to him by father concerning the land. So basically here we have fraud, we have threatening violence. Basically have fraud and threatening violence and conspiracy to commit an offense. So when you look into the statement of the investigating officer, the above stated particulars and addresses are mine. I wish to say that I'm the investigating officer in this case. I received the case file from Commandant Land Protection. I was informed by complainant Flowers that Rukino alias is the same suspect who went to the scene of crime carrying spears, machetes. The suspect ran away, but we later arrested one suspect. Rukon says that he was given the land in writing by his father. Rukon says that Kabera wanted to create a road his house that he had no problem with Kabera doing so. I recorded a statement from their mother, who lives in the same area. Their mother said that her deceased husband had never given the said land to any of his children, but instead they used the land as family. Other family members also distributed the written agreement produced by the suspect. So basically here you see they are confirming forgery and uttering, because you have forgery and also uttering a false document. We have forgery, uttering a false document, threatening violence. Also, we can look at conspiracy. I retrieved the written agreement, exhibited and marked it KS. The agreement was taken to Department of Forensic and with other samples, signatures, and handwriting of that seized. The laboratory report concluded that there were major variations suggesting that the agreement was not written by the deceased but the manner of execution. So these ones are confirming forgery. So when we look at the suspect's plain statement, he's saying that the above are my true particulars. I wish to state that I'm the biological son to the late Brazil. My father had 10 children. In the year 2005, when my father was still alive, he called me and gave me land in writing in the presence of the late Kam Sime, who has gone to work in Iraq. The land had a clear demarcation. A few months ago, my siblings started fighting me on the land. I decided to sell my land to Kabera. Kabera asked me to remove the houses because he needed to clear his access road. I told him that I can help. When I told my sisters, he insisted to harm me. Unfortunately for me, some people I don't know went to demolish the buildings, and unfortunately the police came and arrested me. So basically, you see, is proving we can charge him with forgery, uttering false document. You can also see threatening violence, and also conspiracy to commit conspiracy. So basically those are the offenses they have identified. But in case you like this discussion and you can afford the monthly subscription, please text me on WhatsApp on 07567678284. Then we can add you in a WhatsApp group, and we always have discussions on Saturday and Sunday, and we issue notice. So in case you want to be part of that team and you can afford the monthly subscription fee, then please, you are welcome. We have discussion. We have students from all campuses, 4 campuses, and our discussion are entirely online, and you receive well-researched notes and also cases on the reading list. So please subscribe, like, share, and comment. And I also promise to give you tips for passing an oral exam. So the only way you can pass an oral exam is by preparation. Prepare, and when you prepare, you're going to become confident. So ensure that you understand all your workshops tasks. Then that's where the oral questions come from, because they can ask you to apply bail for your client, for example, or they give you that now your client is at police and you have come to see him as his advocate. What remedy would you advise for your client? So that means you'd have to apply for police bond. And if you have overstayed, you go for unconditional release. So basically, once you prepare, the orals become very easy. So thank you for watching, and please, may God bless you.